Thank you, Mr. Chairman. I want to ask you about a possible means in which law enforcement or intelligence agencies might circumvent the requirements of the Fourth Amendment by acquiring information from third-party data brokers. That is, the Supreme Court in 2018 held that if you're going to seek geolocation information, that a warrant is necessary to compel a cell phone company, for example, to provide that data. In the Electronic Communications Privacy Act, we prohibited the disclosing or selling of customer data to government agencies, but that doesn't cover third-party data brokers. Is there any reason we should allow the government to get information by buying it that they can't get without a warrant otherwise? Be interested in your thoughts, whether you think that should be prohibited or whether there's some argument to be made for continuing to allow that practice.
Thank you very much for the question. I think this is a vital issue. I think, some people may not see the connection to Section 702. It's very much there. Section 702 is part of an ecosystem of often overlapping surveillance authorities. And when one avenue is closed off, the government can often turn to another or exploit gaps in that network to conduct surveillance with no statutory authority at all. And the gap I'm most worried about is this data broker loophole. Federal agencies are buying their way around constitutional and statutory requirements on a routine basis. You mentioned that the Supreme Court in Carpenter held that police need a warrant in order to collect a week's worth of cell phone location data. And yet a veritable alphabet soup of federal agencies, including the Department of Defense, DEA, FBI, IRS, ICE, Customs and Border Protection, are all buying up American cell phone location information in massive amounts without any process whatsoever, not a warrant, not a court order, not even a subpoena. And the way they're doing this is because apparently government lawyers have taken the position that even though a warrant is required to compel production of the data, a warrant is not required when the government merely incentivizes production by writing a big check. So that leaves us with statutory protections. And as you mentioned, the Electronic Communications Privacy Act is woefully outdated. It covers telephone companies and internet companies. They cannot sell data, sell the kinds of data we're talking about to the government. But because this old law doesn't cover...
No, thank you. I appreciate your answer.
I could go on a long time
one
about
other
this.
question while I have time remaining on a different topic, and that is, it always seemed compelling to me when we've had this debate in the past that you should be able to do a search, a query, involving a potential target of a ransomware attack or a location that might be the subject of a foreign terrorist plot or bombing plot. Have we outlawed being able to do those kind of searches by getting rid of about searches, or in order to search a descriptor of a place or a potential victim, would that be caught up in a warrant requirement? And under what circumstances would that be problematic? That is, there are other cases where you have a known potential victim and you still require a warrant. What makes this circumstance different? So if any of you can answer that question.
Yeah, I'd love to take a shot at that. I mean, the reality is that there is no victim exception to the Fourth Amendment. The need to protect victims is hardly unique to the Section 702 context. Law enforcement officials in this country are charged with protecting the public, and they do it every day, and they manage to do it while respecting the Fourth Amendment, including at times by obtaining the consent and cooperation of victims, as well as invoking emergency exceptions to the warrant requirement. So the proposals for a warrant requirement for backdoor searches would all include exigency exceptions. They would include exceptions for victims' consent, and the leading proposals also include an exception for certain cybersecurity-related queries for the reasons you say.
You know, I would welcome it if the chairman will allow. I'd love to hear any counter argument if you'd care to make it. What I'm most particularly interested in is would it be appropriate to search for a potential victim in a case where you may not have probable cause, where you may not be able to show the particularity you would need for a warrant? Is it just the victim's right alone? That is, if there's going to be a bomb threat against the premises, the community has an interest in not seeing that succeed, not just the venue. Should the owner of the venue, let's say some institution, decide not to give that approval, does the government have an interest, nevertheless, in preventing that terrorist attack from going forward? That should override it.
If I could jump in on that, yeah, I think the point of your question is that we shouldn't borrow some of the less functional aspects of existing Fourth Amendment law in this context where we are writing an entire set of procedures for the government that are designed to protect particular aspects of privacy. But you don't want to have a situation in which people say, oh, you put in an address, that's really a disguised search of the person who lives there or people who go there, and you needed a warrant for that. Or you needed a warrant for a victim. Maybe there isn't under the Fourth Amendment, but an exception, but it makes sense to say that the government should move faster and have fewer constraints when they can demonstrate that they're looking for a victim and it's time sensitive.
Senator Coons.
Thank you very much, Chairman Grassley,